Okay, friends, if we can, we're going to try and get started. We've got a lot of material to get through. Are we recording? Thank you. Okay, well, let me just preface my comments. As I was talking to these two friends here, I want to share the same idea with you. These are some of the most compelling clients you will ever meet: the veteran and the veteran's spouse, their survivors, their dependents. These are citizens who have gone to war most often, or who've gone through extreme training. They've endured severe hardships, all because they swore an oath to uphold and defend the Constitution of the United States, just as we've all done. And they've had to go and put their life on the line as well. When you get these cases, many times you will be the only citizen, you'll be the only person really who believes in them, because maybe their families deserted them, maybe they're just alone in the world. You're really the bedrock person who's going to back them up, and you can access lots of services, including services from my office, from the VA. But these are compelling clients, these are compelling fact patterns, and it will utilize all of your skills as counsel, all of your skills as an attorney and counselor at law. And I like to think of it that way because that's really what you are in these cases. You're allowing this person some dignity, you're listening to them, you're pulling out the facts, you're combing records, you're pleading cases. Ultimately, you're probably fighting appeals as well in many cases. I'm going to try and explain this to you in a very simple way, the way that I train people every day among my staff. It's really neat stuff, and this is the nuts and bolts. Now, we've got a little outline here.
I will say it got screwed up, but I think this is really fitting. So the slide is completely screwed up, everything's rearranged. This pretty much sums up VA law. We refer to it,
Yeah.
we often refer to it as the hamster wheel of justice. So, this works.
Now, you've got a really beautiful outline, though, in your materials. It says the VA process. Do we have that in the materials, Diane?
Yeah, it's in the handouts.
Because this is somewhat confusing. But there's a beautiful outline that Diane and I made, and I hope we can find it readily. It's really a good diagram. It wouldn't fit on these slides. We're going to find that before the end of this hour, and we're going to make sure that you know where it's at. And I'll go through that with you. So I want to begin with this. We're going to talk from the ground up, and the foundation. I'm going to hit this a few times just so you think in these terms. If you think about what's a prima facie case for VA, what's a case that really shows you how to get relief, okay? I want you to think of the three legs of the claim. In simple terms, there was an event in service, certainly a qualifying service event. We already talked with Diane about what it means to be a veteran, okay? So there was an event in service. Maybe it was an injury. Maybe it was an experience. Something happened in the military that provided an injury or a problem. Okay, so that's the first leg, an event in service. There's a condition existing right now in the present moment. Okay, that was the first leg of the way Diane described it. Okay, I think of it beginning back in time in the service. That's the first leg. The last leg is something exists now, but there's a connection between them, and it's a medical nexus. That's all your medical data that shows really that, yeah, there was an event in service, all right, and yeah, there's a current condition, and here's how they're connected. And we can get that nexus in a variety of ways from physicians. So I just want to frame everything we do in the context of the three legs of the claim. Any questions about what I've said about that? So just remember that. It's foundational to everything you will do in VA initial pleadings, in VA appeals, all the way up. You got to have those three legs. First, claim for benefits after service. And this is really accurate. By the time a veteran reaches you, most will have filed a claim already. At exit from service, in the last 15 years at least, most members attend, they call it a TAP program. It's an exit program where basically they get assistance with their first disability claim. So a lot of them will file on their own, or a service organization will help them. Vets usually fill out a 21526. 21526EZ is the recommended form now, and I just want to touch on that very briefly. When I got into this business, I was a public defender in Seattle, and I was pulling veterans out of jails, and I was getting them connected with VA, and VA were filing these things for them. I had too much court work, but I had enough knowledge of veterans where I could identify them, and I could find connections with VA. Well, VA was filing a 526 back in those dinosaur days, but now we use a 526EZ, which I really like because it's real lawyer-like. You don't just file a form and say, okay, VA, you collect the evidence. That's what this is. 526EZ, you do all the footwork. And of course, your veteran's going to bring you information. You provide a fully developed claim, which means you're going to give all the evidence to the decision maker. The only thing you don't have to provide are federal records. The VA still, even with a fully developed claim, they'll get service medical records, they'll get federal hospital records. Now, it's nice to have those service medical records in front of you, if you possibly can, because that's really the foundation of your evidence for a claim. So it's really nice to have those, and we can look at how do you obtain those as well. But a fully developed claim with a 526EZ, that's how a claim really is started. And VA says they'll find that within 180 days, they'll make a decision. They're not always at the 180-day mark, but they're sure trying. And that's a big point of departure from the old days. It might take a couple of years to decide a case. So these are really nice forms. And of course, it requires a lot of footwork, but that's okay because you're going to lead the VA exactly where they need to go. And by the way, where they want to go. You're going to give them all the evidence they need right up front. And if you were to file one of these claims, you can probably win that case if you do the right development. You'll get everything in front of the decision maker. You'll never have to have an appeal. That's the best of all worlds. Doesn't always work that way, but that's the ideal. Claim for increased rating. Now, this is really a nice feature. What happens if, like we spoke earlier today, the veteran has a 0% rating? That is still a service connection. Many veterans, when they get a 0 rating, they think, oh, I lost, I was denied. But no, all the elements of the claim were there. Event in service, present condition, and a medical nexus. The only thing is, with a 0% rating, there's no real compensable disability right now. That does not mean that won't change. That might well change as a veteran gets older. For example, hearing loss is a classic claim. If you can get your veteran who's out of the Gulf War a 0% for hearing loss, you've won. And the veteran may come back to you and say, oh, we lost. And you can look at it and say, oh no, this is not a denial, this is a 0. And she'll say, well, what do you mean? And you'll say, you are service connected. And as you get older, hearing loss is going to get progressively worse. And when it does, you can get them relief. And I can tell you, my friends, I've represented literally hundreds of World War II vets. And when they come in, a lot of these gentlemen, and some ladies as well, do not apply for benefits when they were young. They did not apply. But they come in to see me years ago in their 80s. And one of the key claims that I always file is a claim for hearing loss and tinnitus. Because typically everybody was exposed to weapons and they didn't issue hearing protectors in those days. I have literally seen elder veterans become 100% total and permanently disabled strictly on hearing loss. So theoretically, your Gulf War veteran today, let's say a woman goes to war, she's a combat medic, she's in the field in Iraq, they deploy her again to Afghanistan, she's around a lot of weapons noise. She may have some hearing protectors, but in the field she can't use them. She's got to hear the squad leader's directions. She's got hearing loss, but she can still hear partially. She gets a 0 from the VA. That fact pattern is a good one because she's 35 years old now. By the time she's 75, that hearing most likely is going to be very bad. And she can go in and she can get a claim for increased rating. And that's why I've given you this long diatribe. Claim for increased rating. You go in and you plead on a 21526EZ, again, a fully developed claim, and you say, here's the evidence of my client's increased problems. And of course you submit medical records, you give them everything they need. You send them right to the water, let them drink. And typically you can get a decent increased rating. Now, Reopened claim. Take a look at that. A veteran made a claim before, but it was not service-connected, so it was denied. And the veteran didn't appeal, perhaps. Sometimes you're within that year. Now, I want to say right now, if you apply for benefits and you get a straight denial and it says, no, you're not service-connected, you have a 1-year statute of limitations with which to either reopen that claim or to file an appeal. Remember that. That statute of limitations is absolute, and you should, if you have any kind of a colorable case, you should either file a reopened claim, which will continue on from that back case, or you file an appeal, and that'll preserve your rights. If you fail to do that, it's a whole different ballgame. So remember that 1-year statute of limitations. Any questions about that? Okay. Reopened claim. You're trying to open the same claim again. Typically, we do that with new and material evidence. We're looking for something that they haven't seen before, or a lot of times I'll file a reopened claim and I'll ask them to reconsider a decision, request for reconsideration. And that means, take a look at this evidence. I think you missed something. And by the way, here's some additional evidence that really explains what I'm saying. You can get a doc to give you supplemental evidence a lot of times if your veteran is going to a physician for ongoing treatment, which he or she should be doing. If they've got a bona fide condition, then you can probably get doc to elaborate. There was a knee problem, and for some reason VA didn't really catch it. Well, the doc who's done some surgery on that knee can also elaborate. And you get a release of information, you call doc up or call doc's nurse up and say, I really need some additional information, can you provide it? A lot of times doc will do that, especially if they're treating him. So we've got this reopened claim, perhaps it's a request to reconsider. Those are really useful pleadings. New claim. Okay, so you've got a client and you're serving them and they're service connected for a couple of conditions, and they'll come in and see you and they'll say, well, you know, I'm developing diabetes, and this is a Vietnam vet. That's a slam dunk case. We're going to talk a little more, perhaps, if we get the chance, about presumptive conditions, but I'll say this, with our Vietnam vet population, if you see diabetes, lung cancer, prostate cancer, those kind of issues, you can apply for those conditions anytime if you've got evidence that they actually have that condition. And those are slam dunk cases if you can prove there are boots on the ground in Vietnam. So maybe the Vietnam vet comes to you and says, I want to file a new claim for diabetes type 2. Get those old medical records, put in a 526EZ. You're going to proceed on with that claim fairly straightforward. Initial claims, how to. All claims got to be pled with specificity or particularity here. As of March 24, 2015, standard VA forms must be used. Now, I kind of like that. I kind of like the fact that we've got real forms we use. At some point after World War II, maybe it was appropriate to fill out a claim on a cocktail napkin. I mean, I can dig that. I can see that. But over time, the VA has been burdened with so many cases. It's such a huge agency and so many veterans now. Really, you need some standard pleading forms. So they've caught up to the court system now, which I think is really reasonable. Other people will disagree with me, by the way.
I'll disagree.
Okay, and you're welcome to. But personally, I don't think it's that difficult to use a 526 to file for a claim, especially given the fact that we've got VSOs in every city who will assist you for free. And by the way, we've got public contact people to VA who will also assist. But, you know, there are arguments to be made, and I respect those. It's important to get notice to the VA of the claim as soon as possible. That's exactly right. When VA gets notice, benefits can be paid back to this date once you file your claim, or you file an intent to file, and we're going to talk about that. Many vets will want monetary benefits back to service or when the condition started to bother. This is a popular request, both for claims and appeals. However, benefits can only be paid back to the date the claim was made. Now remember this, if you've got a veteran who processed out of service and you file a claim within a year of leaving active duty service, those benefits will run once they're awarded to the date the veteran left service. So that's really important. Be sure and get that claim filed if you can within that year. And of course, filing your intent to file, we're going to get into that real soon, that preserves your date of claim while you're developing your evidence, while you're gathering your evidence and putting your pleadings together. Intent to file. Preserve the effective date if you are not ready to file a fully developed claim. That's exactly right. Execute a VA Form 210966, intent to file a claim. Specify whether the claim is going to be for VA comp, pension, or DIC. Sometimes you can apply for both comp and pen, by the way, and that's really useful because it may well be that your veteran is destitute, low income, and is in need of immediate relief, and you've got a prima facie case for that. You've got a case that says, yeah, he's low income, there's no other assets, he needs relief right now. But you also are applying for compensation. That may take longer. If the veteran can be awarded pension, you've got maybe $1,200 a month that vet can live on, maybe more if there are other factors. So that's really a nice benefit program. And I think this is some of the best laws on the planet. A friend of mine went to the IDF after he went to Vietnam, went to the Israeli Defense Force. He tells me Israel doesn't have nearly the kind of benefits we do, and they're fighting every day. So, I mean, we've got some pretty cool benefits, and you should take advantage of them for your clients. Pension is a great one to use in the interim. Compensation, that might take a little longer. You're going to have to go through C&P exams, etc. Make sure you put in your 2122 alpha. Okay? That's fundamental. They will not accept your pleadings. That's a good way to commit malpractice. You don't send in your 2122A and you file those pleadings. It might take some time to route your pleadings back to you and say they were rejected. So have yourself a checklist. Make sure you always file your power of attorney form. That's what that is. 2122A, that's your power of attorney form, which really says you are on the case.
And
right?
this is true, yeah. No, they really won't accept anything if they don't have your 2122A.
Right.
So if your name is signed to it, no matter what you're saying on behalf of the vet, they'll just kick it right back to you.
And there's a really good reason for you to have your TRIP training here, because if you're TRIP trained through the VA, you're going to have access to what's called the VBMS system. That's the Veteran Benefits Management System. That's the electronic file. It's the equivalent of the Social Security file. If you folks do Social Security law, you're able to look at everything in the record on computer. Same with the VA. That's VBMS. But you can't have that access unless you're TRIP trained.
Is that limited to attorneys only?
No, VSOs have it too. So, I'm a veteran service officer. I practiced law for many years. I got out of that practice and I became a VSO and a chaplain. So, VSOs have that access too.
They also have something they call an agent, which is a non-attorney. They can function, they can do pretty much what attorneys do, but they're not VSOs either.
That's right. But make sure you have access to the C-file. And the reason I'm saying it, you'll be able to check to see if your pleadings are in. You'll be able to see if your 2122's in. So that's really a useful feature. And there's a lot of benefits to this because there's actually a way to online scan your documents and file them direct, and they'll get into the C-file within 72 hours. So there's lots of neat things you can learn that'll really speed up your practice, make it much more high-tech, much more effective once you're TRIP trained. So I figured I'd tell you that because sometimes lawyers think they're out in the cold. They're saying, well, the VA doesn't treat us the same as they treat you. Well, I can promise you this, I'll help you get exactly the same treatment if you're motivated to take that training. I will assist you the same way I assisted her, and she's got all complete access. So it's a good environment in Hawaii for lawyers. And I'm thankful, by the way, that you're all here and actually interested in practicing in this area. So you put in your 2122 with your intent to file. You got to perfect the claim. It's a term of art. You got to perfect the claim, meaning you've got to file your 526EZ or your other claim within 1 year of filing your intent to file, or the effective date will not be preserved. So remember that. You've only got a year. I usually calendar for 3 months. If I put in an intent to file, I calendar for 3 months. I set a timeline with my client in terms of I want certain evidence by this time. Can you go to the doc? Can you get this? I put it in writing. I might put out some letters to the doc, things like that. At the end of that 3-month timeline, I'm pretty much ready to file. If I'm not, I've still got a number of months. I'm going to set another 3-month timeline. I'm going to try and set really firm deadlines for my client because if I don't, it'll never happen. Okay, that's basic casework, something you all know, but I just thought I'd throw that in. That's how I manage an intent to file. Filing claims for service-connected disabilities. Remember, before you file anything, you must have honorable or general discharge from active duty or National Guard Reserve Service with a line of duty determination. And you all have to have the 3 legs of the claim. Happened in service, conditions still exist now, there is a medical nexus. There's medical evidence of a connection. And I want to tell you this, just so you know, there are very few absolutes. That's why I love the law. It's applied philosophy. Okay, we just told you that you need an LOD if you're a National Guard or reservist. But I can tell you, I have prevailed before an appeals court on a fact pattern without an LOD for a person who had terrible things happen under active duty training. Okay, active duty for training, no line of duty determination, but we had contemporaneous evidence. We had a police report and we had medical evidence. Now the VA at the lower level, they will deny and they will hammer on the LOD, and they think that's black letter law, folks. Well, guess what? There's more law than that, and you have to be willing to put your nose to the grindstone and not give up. We did not give up. We fought an appeal over, I think, a 5 or 6 year time period. We did prevail based on the fact that we had a police report and we had medical evidence, and that was good enough for an appeals court. So there's some good things. That LOD, though, will be hammered upon by the VA when you file. So if you can get it, and I want to explain an LOD. A lot of guardsmen in reserve don't know what this is. They'll come into your office and you'll ask them for an LOD, line of duty determination. They're going to say, what's that? Because typically they're not told. But here's what happens. You're a National Guards person. You get hurt on a drill weekend. Now, for those who aren't around the military, a drill weekend means 1 weekend a month. You actually report down to Fort Ruger or somewhere else to do your training and your active duty for training service once a month. Well, in that training, you suffered some form of an injury. You reported that, hopefully, to your NCO or your officer, and it went up the chain of command, up to the unit commander. The unit commander has an obligation to initiate a line of duty determination, which means an investigation, including a medical investigation. And a form is ultimately filled out that says, was this injury incurred in the line of duty, yes or no? If you've got an LOD in the file, you can get some relief. If you don't, you're going to have that uphill battle. Where's the contemporaneous medical evidence? That's what the appeals court's going to want. So I just wanted to explain the LOD because even service members don't know what it is oftentimes. Okay, we got the 3 legs. I'm going to hammer on that throughout this thing. Sir?
If the client doesn't know what it is, how does he get it? It just goes back to...
That's right. That's right. If they're still in the unit, they're going to go back and ask for it. It's very difficult to get. It's like pulling teeth. So that's a very good question. If they don't know what it is and they didn't get it and it's a remote time period, you're not going to get it. So you're going to have to rest on contemporaneous medical evidence.
So they don't have the records?
Well, there may be records at the Guard, but if the unit commander didn't execute or institute a line of duty investigation, there's going to be nothing in the record.
But if he did,
If he or she did, then hopefully it'll be there. Now, I have actually seen a fact pattern and argued this before an appeals court. It's still out. I haven't got the decision. LOD investigation was initiated, at least according to the CO's letter. No LOD was ever completed. Nothing in the file. That really smelled. I think it smelled to the appeals court judge too. And I had a lot of contemporaneous medical evidence. So I think there's at least a chance that I can prevail on that fact pattern. So but I think it's a very, very fine question, and it's a reality-based. A lot of times there is no LOD in the file, and that's problematic for your Guard and reservist. Does that make sense, what I'm saying about LODs? Okay. 3 legs, remember that foundationally in everything you do, my friends. Okay. Fully developed claim. This is really the meat of filing of your pleadings in terms of filing for an initial claim. 526EZ within 1 year of leaving service, okay, or at any time when you're going to plead service-connected conditions. VA will acquire any and all federal records, federal med records, service med records, VA records, Tripler Hospital records, Walter Reed Medical Center records, etc. You, the attorney, develop all the other evidence and submit it with the claim, including all private med records, any other private records supporting the claim, to include employment, voc rehab, or other similar types of records. All required VA forms, for example, if your vet has combat-related PTSD, you're going to include a form 210781. That's a stressor statement. And we're going to talk more about PTSD further on in the course. Do not include VA forms 21, 4142, and 4142 alpha. This is a request that VA get non-federal med records, and it means if you put in this request, release of information, that means you're not asking for an expedited claim. You're not filing a fully developed claim, because now VA is going to have to go out and get those records that you were supposed to be getting up here. You're supposed to be getting all the private records yourself. But a common mistake people will make, because the VA will send these forms out, and sometimes you'll say, well, the government sent them, we may as well fill them out. Don't, if you're going to do a fully developed claim. If you get a 4142 and 4142A, and you submit them with a fully developed claim, it will go in the slow lane, and now VA will be writing for the same records you just submitted. So that's a problem. So just remember that. And your notes that you've been given should specify that as well. And if you've got questions, you can call me. We'll talk about the nuances of that. Now, there is something called the duty to assist, and that's a fundamental principle of VA law. We're not invoking it a lot these days. In fact, the fully developed claim goes around that duty to assist. But in a nutshell, the federal government has a duty to assist a disabled veteran in developing his or her claim. When I first came to Honolulu, I wanted to file the equivalent of an intent to file in some cases I was doing. There was an old term for it, we're not even going to get into it. And I was politely told by one of my colleagues, don't do that. The VA likes to develop these cases themselves, and it's an art. And there were people there that I met, and they had the same books on their shelves that I have, like Vietnam Order of Battle, things that will tell me unit histories when I research cases. So I trusted them, and they had credibility, and I let them develop the cases. But it took years sometimes. So I prefer to develop my own cases initially, but I was told, no, don't do it. Well, finally now, things have changed, and they're saying, yeah, you should develop. But the reason I'm telling you this is, what if you don't have the resources? What if you can't get access to a lot of the evidence you want? You know what? You file a 526EZ, and you can check a box that says, I do not want expedited processing. And you give them a 4142 and a 4142A, and it says, you know, I need records from Massachusetts, and I need records from Pittsburgh, and so on and so forth. VA has an obligation to assist and go out and get those records. VA has a lot deeper obligation than that even, to research allegations that, well, the veteran was in such and such a place at such and such a time. Are there any records at National Personal Records Center that will bear that out? That's all part of the federal duty to assist. If you can, I urge you to do that research yourself and submit it all, because then you know what you've got. If you can't do that, you invoke the duty to assist. And that's something you won't hear very much, but I figured I'd better throw that in. Questions about that? Duty to assist. Okay. From overseas. Could be very difficult. Could be very difficult. And that's certainly something, you know, your client's going to have to face and pay for. If you're having those problems, you may well want to use those 4142s.
I will say it depends where. If the overseas is actually a U.S. military base, it's going to be a little easier.
Yeah.
But if your client lives overseas, like I represent folks throughout the Pacific, I'll usually have them send me the medical records or gather them themselves.
Yeah. If you can get them without having to pay an arm and a leg, you know, sometimes people do not want to divulge records without 25 cents a copy. I don't have a budget for that.
25 cents is nothing.
Yeah,
Here in Honolulu,
$1, $2 a copy. Right. No,
now it's like a $25 processing fee and $1 a page.
I believe it. Oh, I believe it. I don't even have a budget at the state to pay anything for records. So they've got to give them to me for free. If not, if my client can't get them, I'm going to invoke that duty to assist, and the VA is going to get them for free. So it's an important thing to think about, especially with indigent clients. You've got no budget. If you don't have a budget in your law firm and you can't write it off, you're probably going to use the 4142, and that's okay.
And I'll say that's really good advice. I get bills, they're just estimates from Queens and Straub and Kaiser, and they'll be in the thousands of dollars.
Yeah, what a joke. For a disabled veteran, they want $1,000 for some medical bills. They'll give it free to the VA. So keep that in mind. Okay, all statements. Now, I'm going to teach you a basic pleading form. It's called the 21-4138. It's a statement in support of claim. You're going to use that form for all kinds of things. And so I put this catch-all statement here. All statements needed are required from all sources. One of the foundational things you'll do in a claim is have people who were serving in the field with the given veteran write out statements about what he or she saw. Perhaps they were in a firefight and they talk about those stressors. Perhaps in a sexual assault case, someone confided to their roommate that they were raped by another service member, and that's really important evidence in an MST case. There's all sorts of things that you might get other sources to write about. In a sleep apnea case, the person returns from the Gulf War, they were married 22 years, never had problems with snoring, and after living in Afghanistan or the Gulf for a year, having burn pits and poor air quality, they come back and they're snoring terribly and they stop breathing in the middle of the night. Well, the spouse is a very good, credible witness for that, and we'll use our 21-4138 to plead those ideas. So that's kind of the general pleading form that we'll include in this fully developed claim as part of our evidence packet. Questions about that general pleading form? Okay, it's a universal form. You can argue all kinds of things with it. It's kind of like, it's kind of like filing a motion before the court. It's a very similar form. Okay, now let's see. Yeah, VA is supposed to decide within 180. They really are making efforts to do that with a fully developed claim.
So I do have one question.
Yes.
Line 21, 21, 5, 26.
Yes, sir.
Box. You said there's a box. Is that on line 21? Check that box. You say you're not going to do it. You want VA to do it.
Yeah, I'm not sure the exact line, but there is a box that says I do not want my claim to be put through expeditious treatment. It's toward the end, toward the signature page.
The FTC, what does that mean?
FTC, fully developed claim. And that means, a fully developed claim means we've got all the evidence except for federal medical records and federal service records. We don't have to have those. It's nice if we do have them so we can understand what's in them. Okay? But if we don't, VA will still get them. But we want all the private records, we want all the external statements, we want all the extrinsic evidence, whatever evidence we want VA to see, it's all going to be there in a fully developed claim, an FDC. And that means if we do that, we could get 180 days and we could get a decision.
Okay, well, it does say, so it says, I do not want my claim considered for rapid processing under the FTC program because I plan to submit further evidence in support of my claim.
You have it. What that means, sir, what that means is that you've got basically a calendar year to support additional evidence. Theoretically, you've got some time after you file that case. In fact, we're going to go over the idea of the VCAA, the Section 5103, which is a due process notice. Because once you file this claim, if you file an FDC, theoretically, by signing it, you're saying, as a matter of due process, I don't have anything else to file. Okay? But VA is really smart. They don't want to have any due process claims against them. They will send you what they call a 5103 notice. And that notice is basically a due process waiver. It says, either I've submitted all my evidence and please proceed with adjudicating my claim, or I need an additional 30 days. Or you can write something else. I need an additional 60 days, theoretically. So that's kind of the way it works. So that waiver actually is very important.
So if you feel you need more time, you should check this box.
That's correct, because you may need time to develop the case, and you may need VA to go out and develop under its duty to assist. And that duty to assist is very broad. If you look at the case law, the duty to assist is extremely broad. And if you've got the LexisNexis manual, you'll be able to get just a huge a treatise on that subject, as well as infinitely more. Okay, the instructions included with 526EZ are particularly helpful, absolutely. And they really did give good instructions on this form. Okay, claims to reopen. You fill out so a reopen claim, either you're trying to reopen something that was denied, or you're trying to reopen it for another reason. Perhaps you disagree with the percentage of disability that was granted. Fill out a 526EZ, same thing we just talked about, and develop it as you would for any other fully developed claim. You are asking VA to take another look at a claim previously denied, service connection, and the appeal period on the previous denial may have expired. That's true. You could file a reopened claim on a case where the appeals period has expired. If you possibly can, if you're in charge of the case, never let an appeal period expire. If you're in doubt and you've got a colorable appeal, always perfect that, or always file that initial appeal before that year expires. That's bedrock stuff. Always keep your appeal going if you've got any chance to have a case. But let's say it's expired, you're going to try and reopen with new material evidence. And we can talk a little more about that in a minute.
We should totally specify, though, that when you reopen, the back pay does not continue. So they're not going to pay them all the way back to the original date.
That's right.
This is important because you'll get a lot of vets. This is exactly what they're looking for, and this is just not going to happen.
That's right. That's right. They'll tell you they want to go back to the date they left service. And it's been years, and there's unappealed denials. They're not going to get it.
Well, even the date of the first claim.
Yeah.
It's just not going to happen with a reopened claim. A reopened claim means you get a second chance to adjudicate it, but the payment is not going to go all the way back.
The only way that you even could is, let's say, and this is a special thing we call a request for reconsideration. You'd use a reopened claim. You've got a denial. A year has not expired, so your calendar year for appeal has not expired. Instead of filing an appeal, you'll file a reopened claim, and you'll entitle that request for reconsideration. Now that means you preserve your appeal rights. It's just like filing an appeal, but you're not filing an appeal. You're reopening with additional evidence. So your claim will run to the initial date of claim. Now, they may well deny that. If they do, you're going to have a calendar year from the date of that denial to file your appeal. And again, I urge you, if you have a denial, file your appeal well before that year. That way you preserve your client's rights. And we're going to talk more about appeals in just a moment here. Okay? And we got it right here, yeah, request for reconsideration, that's just what we talked about. If the claim is reopened after the prior appeal period expired, you got to have new material evidence, which means new evidence never submitted previously, and material when considered alone, and this is right under the statute, or with other evidence, it must relate to a previously unestablished fact necessary to substantiate the claim. New and material evidence cannot be cumulative or redundant of the evidence of record at the time of the last final denial of the claims, and it must raise a reasonable possibility of substantiating the claim. And we're citing the CFR there, 38 CFR 3.156A. There is no limit to the number of times you can tender a reopened claim. Now I want to talk a little bit about the new and material evidence standard. Under this fact pattern, under new material evidence, okay, so a veteran has a case that he or she has not filed an appeal in, and that 1 year statute of limitations for appeal has expired. That means it is now a final decision. Now you are in new material evidence territory. And I would say, if you looked at this by analogy, to reopen a claim that still has that year, it's like hopping over a little wire. If you're going to reopen a claim that needs new material evidence, it's like climbing this wall with no pressing knots, with no rope. So basically what I'm saying is it's almost impossible to do. You can do it, but you're going to really have to comply with these requirements. And VA is very skilled at weeding out what you've done. Now, If you get a denial on this, my friends, if you get a denial that says, no, we will not reopen, you did not tender new and material evidence, if you file an appeal on that denial, guess what? The only thing before the appeals court is the issue of whether or not new material evidence has been tendered. Therefore, I could spend 2 or 3 years waiting to see a BVA judge. Let's say it gets denied at the first level of appeal, and we'll talk about those levels in a minute. I get before the BVA. The only issue at bar is, was new and material evidence tendered? If I win, if I actually win, case gets remanded, I have to go back now and prove a case with the 3 legs. Happened in service, still exists now, there's a medical nexus. None of that's been decided. None of that was at bar. So you don't want to get into a new material evidence situation because it's an appellate nightmare. It's a time nightmare for your client. That's why I say file your appeal within that calendar year. Okay. There is one glimmer of light in new material evidence. That is a psychiatric diagnosis. The one area that I've been able to prevail, the one area that the VA really is receptive to, and they should be, is you got a denial, your client got a denial for psychiatric condition incurred in service. Many veterans, if they're unrepresented, they don't have a VSO, they don't have a lawyer, they don't have an agent, what do you think they do with that denial? They throw it away. And they go about their life, and they self-medicate, and they try to survive the best they can. Maybe they're even homeless. A lot of our people, Diane and I work with, are homeless. So you get a person who comes in a couple years after denial, and they've got serious psych problems. And they say, what do I do, Diane or John? What do I do? Well, we're going to counsel them to get access to psychiatric personnel, psychological personnel. And we're going to do that through the choice card a lot of times. You know, if the veteran's indigent, they're going to be eligible for VA services. There is an income ceiling, by the way. If you're not service-connected, you've got high income, you really can't have VA medical unless you're service-connected. But for a low-income vet, they're going to be eligible. And then in Hawaii, at least, you can use the choice card, which means basically a veteran can contact a psychological provider who will accept the choice program and go out and start having psychotherapy paid. Well, with a decent diagnosis reflecting service incurrence and a history of psychotherapy, I can take that, I can reopen. That's foundational new material evidence. VA is receptive to it. I can reopen those claims. So that's the one exception to the I have to climb the vertical wall. Well, it's a lot easier with psych evidence. And you know, those are compelling cases, and that psych evidence is really solid, and it's new, and it's not a duplicate. No, it's a new diagnosis, and it's ongoing therapy. It's never been seen before. It doesn't duplicate anything. So remember that. That's a really key piece, and you're going to see that because we've had, 27, 28 years of war now in this current generation? There are huge amounts of psychiatric casualties. And if we only look at the suicide rates for our soldiers, sailors, airmen, and Marines in these last 20 years, we know psych conditions are just mushrooming. So that's a key skill to remember. You're going to reopen with new material evidence with a psych diagnosis from a new provider. That's something I use all the time. All right, initial claims, increased rating. This is the one when I said, okay, you got a 0 for your hearing loss. You might remember it this way. You got a 0 for hearing loss. That means you did have the 3 legs. It is service incurred. You don't have to prove that ever again. Once you get a 0 or above, you don't have to fight that battle saying, oh, this happened in service. That's granted now. Now the question is, how disabling is it? Claim for an increased rating is how we deal with that. Okay? Veteran has a service-connected condition, but the condition has become more severe. You're going to do the same thing. You're all going to fill out a 526EZ, 21 526EZ, and develop it, same you would for any other fully developed claim. To be successful, the severity must be more nearly approximate the criteria for a higher rating. Now, if you get the LexisNexis statute manual, you'll be able to look up every rating in the book. And that's really useful because you don't want to let your client out of your office without having a photocopy or a computer readout of the criteria to take to the doc. You know, if you're going to go there for treatment You're probably not going to go there initially to your doc and say, hey doc, do I fit this criteria? But you know, you're going to have it in your back pocket. So when they're working with you on your damaged knee or your back or your elbows, whatever it might be, after you've gotten your treatment and you've developed a relationship with your provider, it is a completely legitimate question to ask your doc, what does all this mean? I don't really understand it. And you know, at that point, the doc are usually receptive to telling you where you're at on that criteria. That's the way I do it. Practice tips. Examine the higher ratings. That's what I'm just saying. See if the med evidence would show it. Remember this, my friends. VA today is an agency really scrutinizing its own personnel. If you tender a claim for increased rating or a claim for unemployability, and we're going to get into that fairly soon, VA often will look at the case and everything is on the table. All the service-connected conditions that are already connected, VA are going to look at them. And the C&P doc who sees you for an hour might just decide, you know, you're looking a lot better, son, and you might well end up having to defend a proposal to reduce. So we become defense attorneys in this business as well. Instead of prosecuting a claim like we intended for increased rating, now VA are saying, no, your client is better. We propose to reduce, or even sometimes propose to sever. We just defended one yesterday before a hearings officer, proposal to sever. It was unsound, but you know, we're going to have to wait for a decision. So VA will also go on the offensive. So you don't want to apply for any of this unless you've got really good medical evidence and you're sure. Now sometimes your client will insist. Okay, you want to let them understand the possibilities. Sometimes the old counseling memo. I don't know your folks' background, but I was always taught, I was in public service law, Indian law, and in public defense. We always use counseling memos to let our clients know the implications of the course of action they're requesting and put it on paper. That way, that, you know, they've got something in front of them that they can really look and make an informed decision with. You might want to consider that if they're being unreasonable. And sometimes clients will be unreasonable, and they'll say to you, I really want to go for an increased rating. My buddy's got one. You know, my buddy's 100%, and I'm not. You'll hear that a lot. But if they don't meet the criteria, you really don't want to walk into that water because you have a chance of drowning. Okay, let's keep moving here. How do we look on time? Okay, we better keep moving. Disability pension, procedure for claims. Okay, basically 527EZ. We spoke about disability pension earlier with Diane, the idea that you're a wartime veteran, you're low income, and you're disabled for whatever reason, or you're 65 years of age, which is presumptively disabled, for pension. You'll file a fully developed claim, although you'll use a 527EZ. For dependency and indemnity compensation, we'll use a 21534EZ. And the elements to a DIC claim really are a death certificate, medical records indicating that the veteran died of a service-connected condition, or in the case of a 100%er, died of any condition. And of course your 2122A. Always remember to file your power of attorney form, or your pleadings will be rejected and they may take their time getting back to you. So remember that. Initial claims, what to expect after filing. Due process notice. That's what a 5103 is. This letter explains what evidence VA has acquired, what evidence VA still needs. It contains a form asking whether or not you will submit more evidence, which you should indeed return in a timely manner. It is very important to respond. Send as much evidence as possible that the VA is asking for to substantiate the claim. If you've already submitted all your evidence, you'll check that box and you'll say, decide my claim as soon as possible. That's your due process 5103 notice. Compensation and pension exam. This is a med exam VA uses to gain med evidence as to, one, whether a claim can be service-connected, and two, if yes, to what percent it should be rated. Now, the doctor doesn't actually determine the percent, but they'll tell you about the severity, they'll look at all that stuff, and then your rater will actually apply the criteria. But the doc sure does zero in pretty well. At least they should. Best advice to give a veteran is be 100% honest, but do not be pushed beyond or outside what is true. I had a veteran one time, problem with his digits to his hand, severe injury. Doctor reportedly told him, keep moving your fingers until you feel like you have to go to the hospital. You know, that hand was damaged severely in that exam. I argued that before an appeals judge. We got him an increased rating based on the fact that his hand was damaged in a CNP exam. So really, you don't go beyond what you can do. You know, but military members are used to having doctors as officers. They're going to do what the doctor says. You really want to counsel your client. Don't go beyond what you can do. Another thing I always tell my people, and I've got back problems, so I know the problem. If you all got back problems or similar issues, when you get up out of bed in the morning, you've got to do some exercises and some movements, or else you ain't going to be able to walk. Well, I always tell my clients, make sure you have someone drive you into your CNP exam and let them see just how bad you are when you get up in the morning. And that's giving them 100% truth. You know, I once had an appeals court judge order specifically that my client be given another CNP exam, that he not take oxycodone before the exam. And we did that because he had severe back problems. And the doctor at CNP really could not understand that once you've got oxycodone in you, you can move a little bit. But the truth of the matter was, that back was so severe, I ultimately got that client granted individual unemployability by an extra scheduler rating, a schedule outside the 70%. Because of severity. But the only way I got that was I got a judge to order no oxycodone and specific requirements for that doctor to comply with. Sometimes you have to be that insistent before an appeals court, and then they remand it, and then the VA has to follow those orders. By the way, if they remand and the VA doesn't follow those orders, you accept to all that. You tell the VA that in your pleadings, and they'll send it back again, right? And they may do that 2 or 3 times, but you got to really scrutinize what the VA is doing, especially in CNP, because many times they think they've got license to do whatever they want. Let's see. For physical exams, this means stop moving when it hurts. Let the examiner know it hurts. Explain to the veteran not to allow examiner to push beyond your limits. Okay, we've hit that. For mental exams, this means the veteran should not agree to or say anything that is not 100% true, no matter how much verbal pushing and prodding occurs. If he needs to do so, he should be silent until he's able to collect himself. Sometimes in a psych eval, some of these doctors will talk about your childhood, they'll talk about everything but your war experiences. You know, we want to know about that. We want to accept to that, because really that's not appropriate. So there can be problems, but if you prepare your client and you say, I want you to really just go there, give them 100% truth, but don't be pushed. Be respectful and report back to me what happened. If you think there's something wrong, I need to know about it. That's what I do with my clients. Ratings decision. This is the admin law decision that grants or denies benefits. If the veteran does not agree, 1 year statute of limitations to file an appeal. Remember that, that's foundational. First appeal, there's 3 options. All these must be done within 1 year statute of limitations. Reopening for reconsideration, it's a great way to get a decision quickly, preserve your time frame, and not file a true appeal. You submit a 526EZ, reopening for reconsideration, and submit additional evidence to substantiate your claim. If you don't agree with the decision that you get up here, then you should file a notice of disagreement within 1 year and proceed with one of the 2 appeals below. Let me say this to you. I told you about a general pleadings form. It's called a 214138, Statement in Support of Claim. When you file this 52EZ reopening for reconsideration, I urge you to use that general pleadings form to argue your case. You're going to say, veteran is requesting reconsideration for the following reasons. Then I want you to outline your evidence. Outline it all, tab your evidence or number your evidence pages, etc. Your 4138 is really your key for the decision maker to understand what you're doing. So you got your 526 form, you got your 4138 with a litany of evidence and really outlining your pleadings. Okay, that's the way I do it. And that way you lead the horse to water and you let them drink. They want to do the right thing, but you give them all the evidence right up front. Okay, Now, if you have to file a notice of disagreement, what if this reconsideration is denied? Or what if you don't think it's going to do you any good? You're going to file a notice of disagreement, and you're going to file that within 1 year of a decision. Okay? Now, you're going to use a form 210958. It's called the notice of disagreement. And my opinion is you should request a de novo review, a fresh review, by a decision review officer. You can submit new evidence. Unlike appeals we learned in law school, appeals at the admin level before the VA, you can submit additional evidence, which is really appropriate because you've got ongoing medical therapy. Evidence is appropriate in these appeals. You can request a hearing. A lot of times you don't request a hearing on the record at this stage, but you can, and if you feel there's a compelling reason to do so, and we can talk further if you're in practice about why would you do that, you can call me up, we can talk about that. But basically, if your client wants to be heard at this level, you go ahead and ask for a hearing on the record. Otherwise, you submit the 0958, you ask for a DRO, Decision Review Officer review, and you wait for a decision. Never select this route, traditional appeal. This is worthless. This basically is a hearings officer will take a cursory look at the decision, and usually they'll affirm. That's a waste of time. And really, you're effectively waiving your ability to plead your case, to fight an appeal. Take the de novo review by a DRO every time. And these DROs really are excellent ALJs. They don't call themselves administrative law judges, but that's effectively what they are. And they've got some outstanding staff, at least here in Honolulu they do.
I should throw in too, you can't actually get paid until a notice of disagreement is filed. So everything you do before that is for free by regulation.
That's right.
That includes proposed reductions. So we actually do see a lot of proposed reductions, but you can't charge to help the vet with those.
Right. So this is your first stage of appeal, the 0958 notice of disagreement. For all appeals, you're going to expect a due process, 5103 letter, and generally maybe another C&P exam. You should always submit argument based in law and facts as to why your vet's entitled to benefits. Keep it short and easy to understand. And you know, in your arguments, you're not only arguing to a hearings officer, you're arguing theoretically to the C&P examiner, because the C&P examiner has an obligation to read the entire contents of the C-file. That means if you state your case well enough and you can lead that horse to drink that water, you know, given that you've got a good fact pattern, you've got good medical evidence, maybe the doc's even going to believe you. And sometimes that happens. Okay. Short and easy to understand, concise, that's what I'd do. Second appeal, Board of Veterans Appeals, BVA. This must be filed within 60 days of the date on the letter which encloses the statement of the case, the SOC as we call it, the denial of the first appeal. Now, there's another caveat that I never follow if I don't have to, or within 1 year of the date of the denial of the initial claim. Okay? Typically, it takes over a year to decide your appeal in the first stage with the 0958. Okay? What if they decided early? Well, you've got till the end of that calendar year, from the date of denial to 1 year. If you get an SOC in between that, you've got technically till that end date of that first year. But if you hold out and you do that, a lot of times the VA will decide you didn't perfect your appeal within 60 days. You lose. So be careful. In my opinion, the day you get a statement of the case, don't let it sit on your desk. Take a look at it, review it, work overtime if you have to, review it or schedule it for your next day. Call your client and recommend, if you've got any kind of a colorable case, you're going to file your Form 9 within that week. We call it perfecting an appeal. That's a term of art. It means you filed your Form 9, you're going to go before the BVA. Perfect that old appeal within the first few days that you get it.
So we've been talking a lot about time limits. They're going to appeal it within 60 days. How long is it taking BVA to decide?
Well, it's taken probably a year to 2 years to get in front of a BVA judge.
I got to say it's taking me longer than a year. I'm saying at least 2 years.
Yeah, and it takes a couple of years to get a decision. So you may be in for a four-year stint. It's a couple of years to get in front of the BVA, a couple more years to get a decision. And I've gotten decisions, $150,000. I think we've got one $250,000 decision. I ain't bragging. That was living hell for the veteran.
Yeah.
So it does add up. I have no way to get around that. The VA right now, in their wisdom, have tried to truncate the appeals process, and they're going to have some options that you can take. That says, well, you can get a hearing. Well, guess what, folks? You can get a hearing at the DRO level anyway. So, to me, it's smoke and mirrors. But the way I look at it is, don't ever let your client's right to a BVA hearing be compromised, because in this new process, and they haven't really trotted it out yet, but I will theorize that one of the options is just let the local office decide it. I would respectfully urge you not to trust a local office to do something they haven't already done. That's a waste of bloomin' time.
We both win most of our cases at the BVA.
We do. We can't win every case, but we do indeed. We prevail at the BVA level, and she prevails at the CAVC level, by the way. So, that's where you fight your battles. And I like to look at these cases as seasons of war. Just as in the old days, you'd go to war and you'd go home and farm your crops, and it's a cycle. You know what? That's what we do too. We try to find ways that our client can go to ground and survive. We encourage them to continue in therapy and medical care. We plead their case, we perfect their appeal, and then we're in with them for the long haul. And I have seen cases literally that an appeal was filed years and years before. We prevailed on a case that had been filed maybe 10 years prior. I had gone to the BVA several years into that, maybe 6 years into that. I'd inherited the case. I went before the BVA. I argued a sex abuse case that had occurred during Vietnam era. Terrible fact pattern. I believe 3 to 4 years later, we prevailed. That man got, I think, a good sum of money. And he was in psychotherapy the whole time. The reason we won the case was he was in therapy. It was a legitimate case, but we could prove it because we were able to help him get into the proper therapy, and we were also able to help him have some resources so he could survive. And that's another thing. And don't think you're on your own, by the way. VA's got great resources to help people survive. They've got an army of homeless workers right now who actually specialize in getting housing, etc. My office as well, we don't work with the housing dimension, but we can make referrals to VA and private agencies, and we can conference with you on how you can do that. So you don't really need my office. We can talk to you about Catholic Community Service, IHS, etc. There's lots of options. Also, there's lots of options within the VA, like voc rehab programs, etc., that your clients may be able to use. So there's a whole array of resources. But as Diane says, we win the majority of our cases at the BVA level. At the lower level, now, that being said, if you properly file a case at the foundational 526EZ level and you do everything, theoretically you can win right there. Now, everything you do to prepare a 526EZ is the exact same thing you do to perfect a case with the BVA. You're looking at the 3 legs of the claim. Happened in service, still exists now, there's a medical nexus. That's what the judge is going to be looking for. And find evidence from medical providers. Okay, now let's take a look here. You perfected your appeal within 60 days of the statement of the case. Okay, the appeal, if you have to, invoke that 1 year from the date of the initial denial. If by chance they give you an SOC before the denial 1 year expires, of course, you're going to invoke it because your client comes to you after the 60 days has expired and you didn't represent them, right? And now you've come on board. If you decide to represent them, you might have to invoke that at some point. Okay, so be aware of that law. But if you're representing, you perfect that appeal within 60 days no matter what, as long as you've got a colorable case. Of course, ethically, you've got to have some fact pattern on which to provide relief. I would say to you, there's probably a lot of evidence, even if it's the evidence strictly of the veteran. And I have one case strictly on the testimony of the veteran. And I'm here to tell you that a BVA judge can find based on the testimony of that veteran. That testimony is good, even if nobody else recalls the issue. So you can file based on that. All right. The appeal goes on a VA Form 9. Yeah, that's exactly right. You're going to appeal the findings made in the SOC. Decide whether the veteran's interests are best served with a live hearing, a video conference hearing, or a decision on the briefs. Remember, under rules of professional conduct, you must consult the veteran. So you talk about these things. We don't have a lot of time. My bias is to have a live hearing, unless your veteran is so volatile that they're going to get up and attack the judge. And it's rare, but I'm telling you, I've had volatile people where I want a video conference hearing. And that's okay. I've had some excellent judges on video conference over the years, and I've won some decent cases by video conference. This basically is Washington, D.C. judge, and you're going to be sitting in Honolulu, or on Maui perhaps, or on Big Island. We have video conferences all around these islands nowadays. Live hearing to me is the best because you get to sit there with the judge and counsel, and really the judge really gets to see your client and hear his or her testimony. That's the best of all worlds.
The hard thing being they haven't shown up since last year.
Yeah, right. That is a challenge. Decision on the briefs. I have some colleagues who often argue with a brief because their client does not want to go to the hearing. I've seen that with certain cases, and that works too. So if your client doesn't want to go before a judge, you can argue the same things. And if your client wants that, just make sure that you give everything in a very simple, straightforward format. You flag all your evidence, you submit, even if the evidence is already in the C file, you can submit a brief with all your evidence, and the judge is going to have it right there in front of herself. So that's a way to do it. When you go before I'll give you just 1 minute and I'll take it. When you go before that old judge in the live hearing, have your materials there, have all your evidence laid out just as you would in any other court, and of course, you're going to present that evidence as you go before the judge. Lay it right out so it's just a logical course. Lead them right to where they want to go, which is they want to service connect. All you really have to do is show them the truth. And that's what they're looking for.
So it says appeal, but it's actually, it's almost like a new trial, a brand new trial.
Well, we're not going to have physical witnesses in the courtroom, but this is indeed a de novo review standard. It's a very good question because as lawyers, we were brainwashed to believe, and of course in standard appeals courts, it's very rare that you're going to deal with facts. We're always dealing with errors of law, right? And maybe narrow issues of fact based upon evidentiary rules, etc. But we're not dealing with fact. But here, as you've pointed out, sir, this is almost like a new trial. It's not really a trial. It's a de novo hearing on the record. So it's a completely fresh review of everything in the C file and of everything you're presenting to the court, including verbal testimony and the testimony of witnesses through pleadings. We generally use a 4138, which is signed under penalty of perjury. We use doctor's letters. We use medical records. And so it is a fresh review of everything, including new evidence.
New doctor's records.
Yes.
Additional evidence.
Yes. Right now, you can bring new doctor's records. Now, people are trying to change that as we speak. They want to close the evidence before you get before the BVA. I would argue, and I have argued, that that should not happen because this is an ongoing disability case. So if we want to put blinders on the judge and say, Judge, you can only see within this time period, and I can't talk now. I can't tell the judge, my client continues in psychotherapy now, Your Honor, and I have those psychotherapy notes. I don't want to hamstring those judges. And inevitably, and I've got a lot of psych cases because we've got a lot of psychiatric casualties, judges want to see those psych notes. And so I think they're going to be hard pressed to be able to close the evidence because I think the judges want to see that evidence. And I'm going to continue to argue that. And if we get Federal Register on these issues, I don't know how many of you people are into administrative law, but we all know that if the VA is going to promulgate a new regulation under the CFR, they're going to publish in the Federal Register, and there's a notice and comment period. I would urge anybody who's in this practice to just, if you're part of the Veterans Bar, you may well hear about these things, I would urge you to go to the Federal Register and put in electronic comments about this kind of stuff, because it's opinions of practitioners like yourselves, really, that the government will look at, and that can really say, why do we need to keep our evidence open? Well, because it's reasonable, because these are disabled persons in the process of therapy. So how can we close the canon of evidence? We really can't, at least as far as I'm concerned. Does that make sense? Okay. Did I answer your question, brother? All right. Thank you. All right. Now let's see here.
We better wrap it up soon.
Yep, we better wrap it up. Additional evidence can be submitted anytime. Well, additional evidence can be submitted to the BVA up until your hearing. And now you can ask for leave at your BVA hearing, and I often do. Your Honor, may I have 60 days to hold the record open so that I can submit additional evidence? And I also may say to the judge, Judge, may I have permission to ask for an extension if I'm unable to get into those records within 60 days? Judge inevitably will say yes. And it's going to certainly take longer than 60 or 90 or 120 days to get a BVA decision. So you always, when you're before a judge, ask leave if you're going to have evidence, ask leave to have a 60-day window open to submit the additional evidence. BVA will either grant the claim, deny the claim. More often they'll remand to the regional office for further development, or they might do some combination. They might grant partial, they might do a remand. Remands are a place where you can really win your case. The case has to go back to BVA, or to the regional office. And once it does, there are specific orders that the VA has to follow in terms of C&P exam and other things, gathering evidence, etc. Many times the VA will not comply with that, or they'll give kind of surface compliance. Well, Diane and I comb the records, and a lot of times we'll object to what went on, and it'll get remanded again because VA has been hard-headed. So that's one place where you can really win on these cases. Okay, appeals and later appeals, denied at BVA. These are useful. Motion for reconsideration to BVA can be made at any time, or file an appeal to Court of Appeals for vets claims within 120 days of the BVA denial. If a motion for reconsideration is made to BVA within 120 days of the BVA denial, an appeal can be filed at CAVC 120 days after the motion is denied. That's a little practice tip. I've actually won one of these reconsiderations for BVA, and here's how you do it, is you keep good track of all the evidence that you all file in your case, okay? And you got proof that you filed it. I used to say date stamps. Now it's going to be electronic or fax receipts. And we can look at that later if you get into this practice area. I'll show you how to do these things. If you've got proof you filed the evidence, and if the BVA does not discuss that evidence, or if it's not shown on the decision, you can accept to that decision, and I've done so, and successfully got a BVA decision reversed in light of the evidence that I filed that they did not consider. So that works. Another one that one of my colleagues, Nancy Schubert-Euro, won, she got a BVA decision, and it sounded favorable. It sounded like there was a favorable analysis, but the decision denied. She said, this doesn't make sense. We looked at it, we read it 2 or 3 times. A lot of times you got to read a decision 2 or 3 times, just like a statute. We both agreed there's something wrong with this decision. Nancy wrote up a request for reconsideration. Sure enough, BVA vacated that decision and awarded her client. Based on the analysis, the proper analysis was there, but there was a denial. But if we didn't comb that decision and look at it, and we went straight to the denial, which, oh heck, I lost. Never do that. Always go through your complete decision. Look at the errors they might have made. Request for reconsideration, it's doable. Okay. Denied at CAV-C. Now that's the court above BVA. Motion for reconsideration or review can be made 21 days after the CAV-C decision, or file an appeal in the Court of Appeals for Federal Circuit, CAFC, within 60 days of the CAV-C judgment. If a motion for reconsideration or review is made, an appeal to CAV-C is made within 60 days of that adverse judgment. If it's denied at CAV-C, petition for certiorari in Supreme Court of the United States within 60 days, final judgment to CAV-C. In all claims and appeals, develop the claim, just like we did initially. Make a legal and factual argument in writing where appropriate. Keep it short and readable. In developing the evidence, read the decisions and evidence. Don't forget to listen to the veteran at length. That's a key. You will figure out from this what you need to have in the claims file. Consider statements from the vet, but also family members, military buddies, current friends, employers, coworkers, or anyone else who knows him or her and may have observed or knows something to substantiate that claim. If appropriate, file a Form SF-180 for the veteran for the personnel records, because they're unlikely to be in the C file, claims file. Service medical records, if they're not in the claims file, you want to review those records. Private medical records, you for sure got to have those. And by the way, you're only under obligation to file records that you feel are appropriate. You don't have any obligation as counsel to file all medical records in your possession. I would never tell you to mislead a court. I simply say you're going to plead records that are actually appropriate and germane to your case. So don't feel like, oh, I've got 1,000 pages of medical records, I got to submit all these. Nonsense. Find the records that actually fit the fact pattern. Don't burden the court with all sorts of other stuff. Focus in on what you need. And again, don't mislead the court intentionally. Let's take a look here. Private employment records may be germane. Ask the vet what he or she has from the time of service. Travel orders. I just prevailed on a case out of Vietnam era. Travel orders did it. We didn't have a 214 service document that said veteran was in Vietnam on the ground. I told him, find your travel orders. He was getting ready to move to Las Vegas. Sure enough, he had a packet from his old service days. Air Force travel orders. I won that case based on that. So that's very useful. Service records, old that he would only have or she would only have. A nexus letter from vet's doctors. Appropriate forms, especially the 0781, which is the statement showing stressors for post-traumatic stress disorder. Be a counselor. Assist the veteran with the statements. Prepare him or her for C&P exams and hearings. Get copies of C&P exams and review them with the vet. These are often one of the most important pieces of evidence. Usually, they're needed to establish an event. And there's an old doctor hero of mine, Dr. Mendelsohn, and he'll tell you, if you listen to your patient, he or she will tell you how to cure them. It's the same with a legal client. Listen to your client. They'll often lead you precisely where you need to go. They usually will. Common errors. Make sure VA makes a decision on all claims. That's a key. Inquire, notify, and/or appeal when it appears claims are falling through the cracks. VCAA, Veterans Claims Assistance Act. Duty to assist. 5103. Even though VA may say that it did it in the decision, ensure that's true. When there is competent evidence that there's a current disability that may be associated with military service and insufficient medical evidence in the record to make a decision, VA has the duty to obtain a medical opinion. It must be thorough and address the rating criteria. Contemporaneous, it means you got to have a recent medical exam. It can't be an old one. And conclusions must be supported by rationale. You would be surprised how many decisions are based on old exams and with no rationale for the decision. So you got to really scrutinize what the VA is doing. VA must make reasonable efforts to obtain records, with the highest duty being on government records. They must continue to search for the records until VA is reasonably certain records do not exist, or further efforts would be futile. Private records are a lessened duty. VA will only make about 2 attempts and will not pay for them. Duty to provide notice, but VA can try to compel. A government agency can really try to compel Straub Hospital to give them records, and typically they will. Duty to provide notice, 5103A. VA's got to give your client a due process notice, 5103A, with what specific evidence they need and what criteria, rating or effective date that they must meet. Veteran and/or rep, if there is one, must receive notice of a decision. That's a real shaky issue here. We don't have time to get into that, but they've got to mail your client a decision. Typically, they try to notify me on computer through the C file. Determine whether remand orders are followed. This is foundational. We can win a lot of cases on this, my friends. Failure of substantial compliance is a Stiegel violation. 11 Vet App 268, CAV C, 1998. Common VA fails to get the records, the C&P exam does not address everything as required. That's common. Examine the evidence considered in the BVA decision. If you have evidence not considered in the decision and you can show it was before the VA, i.e. it was in the C file as date stamped, you have a basis to vacate, and I've done that very thing just as I said. Okay, when not to bring a claim or an appeal. Use your best judgment. The most common appeals no-goes are vet wants to bring a claim for increased rating or an appeal for a condition where he's headed for surgery and it's likely the surgery will lessen the severity of the condition. You really don't want to bring a case until you know what kind of problems exist post-surgery. You never want to go in blind with a claim when they're going in for surgery. Even if a vet can get a temporary 100% for surgical convalescence, ensure a vet understands it is likely his rating will be decreased or taken away as a result of a surgery. So that can be very problematic. There is nothing additional to be obtained since all, this is an additional thing here. Maybe you're going to get nothing out of it since all ratings go to 100%. So a vet wants to increase for fibromyalgia. He's currently rated at 40, which is the highest rating. He thinks he's going to get 100%. If you can only get a 40, you don't want to go in and reopen that case. All it's going to do is allow the VA to scrutinize that 40 and perhaps reduce. And that's what they often do. They'll give you a sword against what you're requesting. They'll propose to reduce. And that's famous right now in the VA. Vet wants a second rating on the same diagnosis and symptoms, i.e. vet has spinal degeneration for which is rated 100% at a certain code level. He cannot also be rated for x-ray evidence of degenerative arthritis. No pyramiding, right, Diane? Mm-hmm. Okay. So the vet is already 100% or unemployable. We'll look at that in another hour. And the claim or appeal is not for something outside the regular rating schedule. There may be some exceptions. A veteran has IU and he seeks 100% on the schedule. His IU is based on a rating for 70, which VA instead reduces to 30 and drops his IU. You get all kinds of problems with this. So a lot of times you discourage additional appeals or additional claims or appeals simply because it's not going to do your client any good. Vet wants benefits all the way back to the date of the injury, when he or she exited service or at some point before the date the claim for benefits was made. The only exception here would be a Q claim. That's beyond the scope of what we're talking about right now. Diane's going to go over Q stuff in another one of the hours, right?
Yeah, I think we should probably let them go.
I think we should. I've talked a long time. I thank you for your interest in veterans law. And I just want to close by saying this. These are among the most compelling clients you'll ever have and some of the most deserving citizens in this country. I salute you for your interest. Thank you.